All rise. The Court of Appeals Division 1 is now in session.
Thank you. Please be seated. We are here today on Court of Appeals Division 1 case CACV150380 in regards to the marriage of Solberg v. Solberg. Welcome. We are, for the parties' information, we are recording these this hearing, these oral arguments. So as you approach the podium, please state your name and who you are representing. The recording is both audio and visual, and hopefully you will be able to see, if all works correctly, you'll be able to see, have your 20 minutes of fame on YouTube later today. Each side is allowed 20 minutes, and appellants, you may reserve a portion of your time for rebuttal. And if you would like to reserve a portion of your time, if you'll tell us how much time you'd like to reserve, we'll try not to horn into your time too much. So with that, we may begin.
Good morning. May it please the court. My name is Mark Shields. I represent the appellant, Dr. Eric Solberg. The main issue, or the first issue that led to this action, was a request to divide a residence, a rental property that was not divided in the initial decree. Now,
and to the extent that's true, it wasn't appealed either, right?
That's correct.
So why are we here today?
Well, Your Honor, that order could have been appealed, and if it had been appealed initially, there would have been tens of thousands of dollars incurred, a few more years of litigation.
But if we heard every issue that could have been appealed whenever, that would mark a sea change in appellate practice, wouldn't it?
Exactly. My point is that at the end of that day, the court, in all likelihood, would have simply remanded the case with instructions to divide the asset. That would have taken years and cost significant money, put the parties in the unfortunate position of being in continued litigation. Instead, what we did simply, after trying to work within the parameters, filed something to divide it. And that, as I pointed out, is the same thing that happened in the Cooper case. Now, as I look back through the pretrial statement in this matter, I was frustrated with the lack of an actual position on wife's part. Wife did not raise the argument that the court said, saying it's not subject to relitigation because it wasn't appealed. Instead, her position was basically a litany of ad hominem attacks. From that, I was not able to divine something definitive on what her position was, what she truly wanted the trial court to do.
But when we're talking about jurisdiction, I'm not sure that wife's position matters. We have an independent duty to examine our own jurisdiction, and this seems to be an appeal filed well after 30 days from the offending order, if there is an offending order.
Thank you. And again, the point is that, yes, it could have been appealed, but we also have several decrees that do not award an asset, period. They do not divide the asset, and that's the same position that this asset was placed in.
But wasn't it really divided? I mean, both parties hold the property as tenants in common.
It was not divided, because even the trial court, Judge Anderson, acknowledges that it was not divided, that it was simply awarded to both people. Wife has pointed this court to an example that predates the 1973 amendments that require the court to divide it. It puts the property in the same situation as an undivided asset under 25318D, as I pointed out, and that is also explained, I believe, well in the...
Mr. Shields, I still don't understand why you think it's not divided. It's mentioned in the decree.
It is mentioned in the decree.
Both parties have an undivided one-half interest in the property. If it's not like they're holding it as with rights of survivorship. They each have a 1/2 interest. I understand that you don't like the way it was divided, but the fact of the matter is, I just don't, I'm not following your argument that it was an undivided asset. They each own 50% of it.
They each own 50% of it, just as they did before the divorce. And that is the
No,
point.
not just as they did. They owned it as community property before. Now they own it as tenants in common, which, by the way, would be the legal consequence of having it as an omitted asset.
Exactly, and it's for that point that I say we're in the same situation as we would be under 25-318D. The standard procedure when that happens is exactly what happened in Cooper. Okay, by operation of law, it's owned as a tenancy in common. Now, is that considered a division? No, because in Cooper they pointed out that it comes back to the Superior Court to divide it. Judge Orozco, more to your point, I would draw the court specifically to the language of the current version of 25-318A. It requires the court to divide all jointly held property. Community property, tenancy in common, joint tenancy, there is no difference. They are all subsumed under the current language of 25-318D.
If this were a savings account, and the court had ordered that each party gets a 1/2 interest in the savings account, you wouldn't be here because you could just withdraw that 1/2.
Exactly.
But it would still be a tenancy in common in the savings account, right?
But it would lead to an actual division because that money would be
Just be
withdrawn, as the
easier
court
to
pointed out.
divide because that's a liquid asset. This asset isn't liquid, but there you have the asset. The ownership is specified. Each party has an equal ownership. That sounds an awful lot like division to me, and it sounds like an awful lot like a division that the statutes contemplate.
And again, I point the court to the plain language of 318A that says when we have property that is owned, as was stated in the original decree, the court is required to actually divide it, not just to keep it in the current state where each party does have an ownership interest in it.
So what would have been an acceptable order? An order that it be sold?
Yes.
Okay. What else?
The problem stemming from the failure to divide it is that the court initially did not even specify each party's responsibilities to it. It said neither party is responsible for the mortgage, et cetera. That's what led to the problems that do appear quite clearly in the record.
But let me then ask you, what was on the court's menu of, in your view, appropriate orders? The court could have ordered it sold. Is there any other possibility?
Either party would have had the right to buy it, just as would happen in a standard divorce situation. The question, there were alternative positions presented to the Superior Court about how to do that because there was a shortfall in equity. But frankly, there was a shortfall in equity in the vast majority of divorces post the 2008 crash.
But then the statute could just say the court must order all community assets sold. It doesn't say that. The statute contemplates that there may be joint ownership of property after divorce, and to the extent you're arguing the contrary, that would be a dramatic change in the interpretation of 318.
And respectfully, I disagree because the court therein is obligated to divide property, not simply to keep it as joint ownership and consider that a division. That's not the case. 318A is specific. The court shall divide all community, and it enumerates several other types of joint ownership.
As Judge Swan has intimated, an order that the property be sold, by your argument, also wouldn't comply with the statute that requires that it be divided.
It would, in that it would dispose of the asset. And in that case, I believe that disposition and division are synonymous.
What if there's no buyer?
It's the same situation we would be in any divorce. Again, as I pointed out, the vast majority of divorces post-2008 were in that exact situation.
Right.
It's difficult. It's very difficult, but we get through. And the last thing we end up with is two parties required to co-own, required to cooperate when they obviously can't do that. This home was not a child. Parties post-divorce need to cooperate for the sake of a child, not for the sake of an asset, not for the sake of trying to figure out who is responsible for what. For example, when husband paid all of the mortgage, incurred a shortfall, yet wife claimed it on her taxes.
Isn't the real remedy here, if you don't like the tenancy in common, a civil action for partition?
I suppose that's possible. But by all appearances, the trial court would still retain jurisdiction over that. I hadn't thought of that, Your Honor, and if that truly is a burning question in the court's mind, I would request permission
I don't know if it's burning.
to address that with additional briefing. Be that as it may, the problems were evident in the record. These parties could not continue to co-own this property. They should not be expected to. I would point the court again to the ruling. The specific statement is petitioner's unwillingness to continue to be partners with respondent is not good cause to deviate from the terms of the decree. Unwillingness to continue to be partners. That's the very essence of a divorce. And parties are not denied that under Arizona law. If they are unwilling to continue to be partners, they are granted a divorce. And with that, again, under 25318, the court is directed to divide that property. Her statement here.
Let me ask you a different question then. Let's say that instead of owning this property personally, the parties owned shares in a corporation that owned this asset. And there were 100 shares, and the court awarded each party 50 shares. Is there a problem with that?
I don't foresee the problem, no, for the same
Aren't they
reasons that I
partners,
pointed out.
effectively, in a closely held corporation owning a single asset?
I think the court's, as I read the court's question, it's assuming that someone else is still responsible for management, that they're not required to continue to cooperate.
It's just husband and wife, Inc., and it's a corporation with 100 issued and authorized shares. Each party gets 50. The corporation has one asset. If nobody manages it, the corporation might lose that asset, but
Correct.
Each party has 50 shares. That, in your view, is okay.
Again, I'm answering the question in what I perceive to be a bit of a vacuum. I'm understanding it 50 shares in Intel apiece. Obviously, that's a fair division.
In a closely held corporation
And that
created solely for the purpose of owning this one asset.
If it's created solely for the purpose of owning the one asset, there would still be problems. So I think that much is obvious.
So the court can't even assign numbers of shares in a corporation if it would mean that these parties would theoretically have anything to do with each other.
I think that's a little bit too far removed. I would not go that far to say. What I will say is this record on this case, these facts before the court show that the asset was in fact undivided. Don't take my word for it. Take Judge Anderson's. And again, look at 25318A. That failure to divide has proven very problematic. Judge Anderson's ruling again states unwillingness to continue to be partners. That's obvious. That would be expected following any divorce, but then she follows that up with quote-unquote good cause. 25318 does not require good cause to divide an asset. Parties are entitled to that because the legislature said so. And the legislature said, don't make them continue with joint ownership. And especially, this is our case in point. I will close this issue. I apologize, I've spent far too long on it than I anticipated by noting that I didn't find any case law that approves of continued joint ownership and tenancy in common. I can tell the court from my own experience that when that does happen because of an omitted asset, we go back to the Superior Court and nobody bats an eye over it. I will also tell the court that the only case that wife found for that subject is based on outdated statutes, far outdated statutes. So if this is in fact divided as the court has inquired of me, I do not see any case law to support that position under our current statute as it has existed for over 40 years. To the maintenance issue, I led with the Norton case. Wife never responded to that. She didn't mention it because it's very clear when a change in needs is not considered, and that's the key word that appears throughout Norton, that is an abuse of discretion. It was not considered. It appears nowhere in there in the ruling. Her AFI is very clear that she does not incur many of the expenses on which the original maintenance award were based. They come out with a different argument saying, well, yeah, but she has new expenses. For example, she's now paying a housekeeper. Well, that was not an adjudicated reasonable expense at the beginning. We don't replace necessary expenses, because that's the key touchstone under 319, with whatever expenses we want. The car is gone, the car payment is gone, the car is paid off. The insurance is not $300, it was $50, and that's $50 for the whole family. It's not even $50 just for her, so the other share would be accounted for in a child support order. The credit card expenses that existed would have long been paid off with the maintenance that was ordered, and so on and so on and so on. Again, the failure to even consider that, as it appears nowhere in the ruling, is black letter reversible error. This is one changed circumstance, one in a wave of several. The next one is her income, obviously.
Well, there's nothing in the statute that requires an accounting of expenses, right? The spousal maintenance statute is constructed to afford a spouse a reasonable time to rehabilitate, to achieve a certain standard of living. I don't think there's any universe in which a $1,000 a month Mercedes payment could be considered a necessary expense. But it is an appropriate consideration the way 319B is drafted.
And that expense no longer is there. It wasn't addressed, falls squarely under Norton. That's an abuse of discretion. And again, this is one wave. And even the $1,000 Mercedes that the court pointed out is but one of them. There are no housing expenses. No housing expenses, period. She doesn't pay mortgage. She doesn't pay utilities. It's all a shared expense with her new boyfriend. All in all, we're looking at $3,000
And isn't that really
in
the
decreased
issue
expense.
here?
Pardon me?
Isn't that really the issue here?
It's part of it, yes.
Yeah, and if the idea that a new romantic involvement might change expenses were relevant as a matter of law to modification of spousal maintenance, the statute would say it. What the statute says is that remarriage terminates the obligation. It doesn't say that being on the cusp of remarriage affects the obligation.
And we were very clear about that in our petition. We acknowledge that that is not a per se, but there's case law on that. I cited it in the briefs. I'll have it ready when I address rebuttal. I said it was but one part of it, but it is a huge part of it because it's $3,000 in decreased expenses. And by the way, Judge, we weren't asking for a termination as would happen under a remarriage. We were asking for a modification downwards of only a fraction of the entire award. Her income is the huge one. I'm not sure where the $2,500 statement for her income came from in the initial ruling because the W-2 for that year showed just over $15,000 of income for 2012. That's the year of the initial award. The very next year, it more than doubled. And by the end, which actually would have more than tripled the actual income. So by the end of this record, where the trial court left off, it was undisputed that her pay was now 90% greater per hour. This court, and I'm sure no other court, would want to be in the position of claiming that a 90% hourly income and what is essentially a 200% de facto raise would be considered insignificant. I will reserve my remaining 3 minutes for rebuttal.
Would the opposite be true? If your client's income went up 90%, would wife be entitled to claim a piece of that by an upward adjustment?
That's possible. It's
That
not the
sounds
fact
a lot
that we
like a
have.
partnership to me. That sounds a lot like the continuing involvement that you were just arguing against with regard to the tenancy in common.
I'm not following, but again, my point on this is that there are multiple changes of circumstance, all of which were ignored, most of which don't even appear in the findings. Again, I'd like to reserve the remainder of my time.
Thank you.
May it please the court, good morning. My name is Stanley David Murray, and I'm representing the appellee, Rebecca Solberg. Seated at counsel's table with me is Lisa Johnson-Stone. She's co-counsel for appellee, and she also represented the respondent in the lower court proceedings. Appellant raises 3 issues for this court's consideration on appeal: the division of property, the modification of spousal maintenance, and the award of attorney's fees. All of these issues are subject to the abuse of discretion standard of review, which means that the court reviews the record most favorably to upholding the trial court's ruling unless it's devoid of competent evidence to support that ruling, or those rulings in this case. Let's start with the Electra property, the rental property that Judge Swan was asking about. We found a case, Nesmith versus Nesmith, that says, yeah, we don't like doing this. We don't like to see community property given to the parties either as tenants in common or whatever other division that you do. But that is a division, and that's how it works. So that's fine. If you didn't like it, you should have appealed it. And by the appellant not appealing the decree when it was entered back in 2013, he's waived that issue. So the only option that he has then to challenge that ruling would be the claim that it's an omitted asset. Well, he cites to the Cooper case, which is not on point here because the Cooper case definitely did not include a retirement plan that had to be divided subsequently. I believe it was 20 years later when the wife finally found out that husband was getting that benefit.
Well, in fact, on that point, I have long thought that that was the main reason for a statute like this, is because although we have quadros, pensions a lot of times can't be divided because they aren't a palpable asset until they can be valued, and sometimes they're not vested, and so you have a statute here that says if you need to, you can wait till the particulars of the pension are known, and then you can divide it up then.
Yeah, that's
And
true.
I thought that was almost kind of the quintessential asset
Right.
to be covered by a statute like this.
And that's exactly why that statute wouldn't apply to a situation where the decree specifically identifies that asset.
We
and
have
divides it.
it seems to me we have other doctrines for things that are just sort of inadvertently left out or unaddressed. I mean, you have 60C, and you have other exceptions to issue preclusion and things like that. But something that, I mean, if you just divide up assets generally and don't mention like guns or, cars or something, it's been divided even though it wasn't specifically addressed.
That's true. The catch-all phrase of Lamparella. Yes, sir. Well, you did raise a point, though, at 60C. I was going to talk about 85C. Divisions of property are final unless you can show under 25327A that under the laws of the state of Arizona, it can be modified, and that's where you go back to Rule 85C. They did not allege Rule 85C, and so they've waived that issue as well, because that would have been the appropriate procedure to bring that issue up to the court.
Under the, perhaps between the lines here, there is another problem, though. It's all well and good to say that the court divided the asset and gave everybody a 50% ownership, but that has the unstated effect of dividing debt or assigning responsibility. Now, if one party doesn't meet his or her fractional share of that responsibility, has the court in effect created a business entity, a general partnership, that it lacks the authority to create?
Unfortunately, we didn't have that situation here because you recall from the decree, the parties weren't required to make any payments on that property except for any rental income that they received. So they weren't personally obligated to enter into that partnership, as the court is asking about. Yes, but to answer the judge's question, that would create some sort of a partnership agreement or a relationship that I don't know. It hasn't been decided yet that I know of, but it's kind of different from the Nesmith situation.
Well, it is. And you're saying that the record here exposes neither party to any liability?
Yes, sir. I believe it was the master's report that gets into the details about how none of you guys are going to be responsible for the debts, the maintenance, but if you do collect the rents, you put them in this Hansel account and use that account to pay off those liabilities. There's no personal liability, if I recall correctly. So if Rule 85C did apply, the only basis would be for lack of jurisdiction, because the grounds that he doesn't want to be a partner anymore with the wife wasn't sufficient. It certainly isn't listed under Rule 85C. But again, the Nesmith case says that there was jurisdiction to do it that way, so an 85 argument would not have prevailed.
What if Mr. Shields' argument that the Nesbitt case is an old case and doesn't, and 25318A has been since amended? And
it hasn't been amended that drastically. And in fact, in the Nesmith case, they divided community property. So you can always divide community property. If you want to change it from community property to tenancy in common, there's nothing in that statute at that time that said you couldn't do it. And in fact, what was I going to say? The the court cites the statute, and the statute says the court shall divide property in a just and fair manner rather than fair and equitable that we have now. So I think that's the only distinction between the two statutes. So the trial court did not abuse its discretion in denying father's petition to modify this division of property. On the modification of spousal maintenance issue, remember the father has the burden of proof to show a substantial change of circumstances and continuing change of circumstances. We admit there was a change of circumstances here. Mom got a raise in the airline business. She has less expenses, and she has different expenses than she had before, but they weren't any less. And if we went through each of these issues here, let me address first of all the Norton case. Mr. Shields says I should have addressed the Norton case in my brief. But if you'd read the Norton case, you would see that it wasn't really applicable to our situation, because in Norton, the court was reversed for not allowing the mother to present evidence of her living expenses, which the court has to consider. In this case, the court considered everything, the income and the expenses of both parties, because there was testimony to that effect. So Norton doesn't apply, and I guess I should have responded to it, but I don't see the significance of Norton in our situation. Mother's income at the time of the decree was $3,500 per month. That was based upon the job that she had with, I guess it was America West Airlines at that time. She was making like $21, $22 an hour. Plus, the court had imputed or attributed income to her from a dental hygiene practice. Now, at the time of this present order, she was earning $3,400 from the airline, but not working in the dental hygiene business. There's nothing that requires the second judge to attribute income at the same level as the prior judge did. So if mom's working at a job now where she's making twice as much as she was before, and she's working full time, by the way, I refer the court to Exhibit 9 to describe what 70 flight hours or credit hours means. It's like a full-time job. You don't have time to be a dental hygienist because you don't know what your schedule is going to be. You're not available on call. You are for the airline, that is, but not for any dentist office where you could gain that extra income. And she also had medical issues. She testified about tendinitis and migraines that were preventing her from doing the dental hygiene job. And again, it's up to the court. Credibility, weight of evidence, these are all factors that the trial court has discretion to consider. And it's not up to this court to say, well, you should have added something that you didn't add unless there's a legal basis for doing that. Father's income at the time of the decree was $20,000 per month. And at the time of the order, he's claiming he was only making $14,000 a month, but then he amended that to $16,000. Well, he left out, as Ms. Johnson-Stone was able to raise on cross-examination, income from a second job that he had. He worked on Wednesdays with Save On Dental, earning about $3,000 per month in that job. He had previously rented the casita on the premises for $2,000 per month, but didn't disclose that either. And now he's in the real estate business. And I admit he only had the one sale, but at least he has additional means of generating income. Again, the income doesn't change. It's still close to $20,000 from the time of the decree to the present time. Mother's expenses at the time of the decree were $6,500 per month. At the time of the order, they were listed in Exhibit 1 as $6,600. Mr. Shields, I think, raised the issue about the income that she received from the rental properties. But if you look at Exhibit 1, there's a footnote that explains she was paying the mortgage and the maintenance on that rental property because husband had given it up and gave her full control and authority over it. And so while there wasn't a renter there, somebody had to pay the mortgage and the expenses, and so that's listed as her housing expenses that she had to pay to maintain that property. The groceries increased. I'm not going to bore the court with all the numbers, but when you add everything up, the expenses haven't changed anything at all for mother. At the time of the decree, father's expenses, they were the same as mother's according to the report done by the special master at $6,500. But at the time of the order, father's no longer paying for the kids' tuition. I think it was their daughter that was going to a private school. He was also paying for a nanny at $1,200 per month and extracurricular expenses for the kids. Those expenses don't exist anymore. Now, he did testify that our daughter now is going to LSU, but in January 2015, she wasn't going to LSU, and he didn't submit any evidence to show what these anticipated expenses were going to be. So again, the province of the trial court was to give weight to that testimony. Was it convinced that father was going to incur about $38,000 in expenses? Apparently not, because the court did not show any sort of reduction in his expenses. or take that into consideration as a change of circumstances. So again, the evidence submitted showed no substantial and continuing change of circumstances to merit granting of its petition for
Was the special
modification.
master involved in the modification proceeding or the original proceeding?
In the original proceeding, Your Honor, the trial court simply adopted those findings in the decree. The award of attorney's fees, real quickly. Obviously, financial disparity existed here. I don't think the court needed to make any findings in that regard, and nobody did ask for findings in that regard either. But the judge did go into the reasonableness issue and found father had taken unreasonable positions. For those same reasons, we're asking for attorney's fees on appeal and ask the court to affirm the judgments of Judge Anderson in their entirety. Unless the court has any questions for me, thank you very much.
To the court's point earlier on cohabitation, Van Dyke v. Steinley cited in both the opening and the reply briefs, that was a remand and abuse of discretion found on the same subject before us here. Payments that were obligations before were no longer obligations because of cohabitation, black letter law. Yes, it is fair game. No, we're not trying to rewrite any statute and claim that cohabitation equals remarriage and therefore termination is automatic. I am disappointed in many of the things that Mr. Murray stated. I pointed out in the reply brief that they are simply untrue. He persists to this day. I take issue with that. My client takes issue with that. No, he did not leave out income. His income was adjudicated, the only adjudication we have in it since the original decree, at a decrease of $3,400 per month. That's 17%. That's insignificant? No. It does go deeper. He still did not mention the college issue. While that doesn't fit in dishonesty, it's important to note. Well, I take it back. He addresses it through saying that that my client is saving expenses and therefore it's a wash. No, there was no nanny at the time of the divorce. The record is clear on that. He testified they did that when they were a two-earner family. That was gone by the end of the divorce. That doesn't free up money for him. With respect to saving the tuition at Xavier College, as I pointed out, that is a fraction of the $38,000 in tuition and books necessary and proper for consideration under 25-319. The claimed expenses are...
It seems like, at least in part, that your argument is that the judge didn't consider this evidence that you brought out and didn't weigh it. But was there any findings of fact or conclusions of law? Did you ask for them from the court?
They were not requested. The only findings that were made were as to her income, which again defies the numbers that I have presented to the court and which are clear.
Without specific findings, don't we have to presume that the court considered all the evidence?
No, because...
Just because you don't like the way it came out doesn't mean that that the court didn't agree with it because you didn't request findings of fact.
I am assuming that the court looked at the evidence and somehow held that a 90% hourly rate pay increase on wife's part is not substantial. That's wrong. What she held as to husband, it was obviously a typo. It doesn't make any sense. But his adjudicated income had gone down too. No mention of the college expenses, which are well over $20,000 more than what he's claiming that my client saved through other methods. It's simply not right. So adding all that up.
Wrap it up. Your time is up.
My apologies. Does the court have any questions for me?
No. Thank you. Thank you. We will take the matter under advisement and issue a ruling in due course. We're going to take a brief recess to let the parties the new parties come up, and we'll be back.